Hello, everyone, and welcome to our webinar, there we go, presented by LAMCO Wellness and Kiswani Law Firm. I'm joined by Dr. Tracy Tilton and Mirvat Mohammed, uh, an attorney with Kiswani. Um, and we're going to talk about the association between mental health and outcomes for family law settlements. I don't know if I'm using the right word, Mervat, but the outcome of family law cases. There we go. Uh, so I did want to ask both of you as we just kind of started things off, if you wanted to introduce yourselves and just kind of say, who you are, why you're here.
I'm Dr. Tracy
Would you like
Dillon.
to
I
go
work
first?
for Wellness. I'm here just to provide some feedback about and suggestions for what people can do as they go through family law cases, like specifically custody evaluations, um, and other types of divorce, things like that.
And Mervat?
I am a family law attorney who's been practicing family law for approximately 12 years. I'm very excited to be on here to talk about how mental health impacts family law or vice versa.
Awesome. So without any further ado, I want to start off with for both of you. We'll start with Dr. Tilton and then Mervat, feel free to chime in as it goes. But where does legal stress and emotional stress most commonly collide for clients? And how can both sides of the spectrum, both professionals rather, work together to reduce the negative impact of those events?
But I think let's take custody evaluations. They're highly conflictual typically. And a lot is on the line. You could lose custody of your kid potentially. So people are very emotionally invested in it. Um, but they can experience reduced cognitive control, which leads to poor decision making, increased interpersonal conflict, especially with their spouse or ex spouse, whatever it may be. Um, and they have what we call flooding, and that's cognitive reduction, where you just have like cloudy thinking and you can't make a good decision really when your thinking is that way. It's hard to think rationally, and to manage your reactions because you have emotional dysregulation as well. um, and because it's often high conflict litigation, you also have like impulsive actions, which then you also don't make the best decisions potentially. um, and it can further increase legal fees, court time, distress. It's just a lot of unhealthy things that come to the forefront when you're going through something this stressful.
Yeah, yeah, absolutely. Mervat?
So I don't know where to start because with family law, it's all stressful. So usually I think the impact is at the beginning. And I tell this to all my clients and anyone who speaks to me. As soon as we sit down, the reality is you're either here because there is a contested divorce or a contested custody battle, or you're here for an order of protection. So it's very litigious. So, of course, that's anxiety based. You have maybe mental health issues, or you just need to talk to someone who's not your attorney who can help you throughout the case. And attorneys are not mental health providers. So you can vent to your attorney all day long, but your attorney cannot give you medical advice or therapeutic advice or coping advice. And you need to go see a professional who can actually help you with that. Throughout the process, whether it's a divorce, whether it's a custody battle, whether it's a domestic violence order of protection, the court cannot be the one to diagnose you to see if you have any issues of mental health. We don't do that. The legal system does not do that. We rely on professionals. And I tell clients that come to me, even if they don't have necessarily mental health issues, that the outcome of your case can go drastically better if you have a therapist on your side who can talk to you about all the things that impact you in the case. So you come in with a point of view that is clear, collected, and more logical, rather than resentful, emotional, ego with pride. So family law needs the therapeutic component, regardless of whatever stage we're on.
Well, yeah, and there's also it can be a lot of physical and emotional exhaustion. I mean, like the hearings can be really draining. Constant threat to either your finances or losing your child. So a lot of people have anxiety. They have lower frustration tolerance, irritability, depression. Some people have described the process of either a contested divorce or custody evaluation as very traumatic. So some people even say that get diagnosed with PTSD on occasion. So those all require the help of a therapist to help you resolve the issues.
Mm-hmm.
Yeah, from a personal perspective, I feel like, family law cases are inherently super stressful, as Ravat was saying, and it's also a situation where you don't necessarily know the timeline on it. Like a lot of times, if I'm in a stressful situation, I'm like, okay, well, I just have to get through to the weekend, or I just have to get through to wherever. But there's continuations, delays, things of that nature, and I think that just heightens the level of stress. And I agree completely. You really should have somebody in your corner to just help sort you mentally so that you can come in clear-eyed, fresh-faced, and ready to make those tough decisions, and listen to those tough conversations potentially.
Absolutely.
Right.
So I did want to ask as well, what misconceptions do clients often have about therapy or legal strategy during these divorce and custody cases? Uh, Mervat, if you want to start.
Sure. Some people come in thinking whatever they see on TV is the reality of the legal world. And that certainly is not true at all. We don't have like a paralegal running into the courthouse with evidence they just found miraculously in order to win a case, or, not everybody has money to pay a private investigator to find out all the intricate details of the other person's life, or attorneys miraculously are jumping from court to court, or they're miraculously having last minute conversations with their clients, and then they come up with a magical, extraordinary legal strategy to win the case right before trial. Like, none of that is true. The TV obviously is selling a facade. So I think that is misconception and unrealistic expectations that some people come in with. They come in with wanting their divorce or their custody battle to be done in such a fast pace, or they want, these expectations of finding out certain information about the other party through an attorney. And attorneys, we have some, I would say, limited, let me backtrack on the word, limitations as to our role, right? We're not a private investigator. The attorney themselves is not going to be, chasing after the other party, finding out information. So I think also there's a misconception about the cost. If you want all the bells and whistles in your divorce, including all the extras, the PIs, the subpoenas, the depositions, it's going to come at a very hefty cost. And again, unlike TV, your divorce is not going to be over in 2 episodes. It might be over in the timeline of like 6 months to 2 years, depending on the issues and depending on how far both parties want to take it, whether that's in litigation or whether people actually want to sit down and talk and try to settle their case.
Yeah, and speaking of things being misportrayed on TV. I mean, a lot of people think of therapy as like sitting on a couch while the therapist sits with their back to you and asks you how you feel about your mother, and that's just not the reality these days. It was like 80 years ago, but it's not now. So, I mean, a lot of people think like, well, I can just talk to friends. If I'm just going to go there and talk, I can talk to anybody about it. But we're not like just chit chatting. We're providing you with tools and insights so you can make the best decision. We don't give you advice. That's not our job. Our job is to provide you with the ability to make a sound decision that's best for you and your family and the process. And you think that, like all therapy is the same. Like usually what's portrayed on TV is like psychoanalysis, but in this day and age, it's more like cognitive behavioral therapy or dialectical behavior therapy, and those provide you with skills like mindfulness skills, emotional regulation, better communication, all those. So, it's not a quick fix. It requires time and effort and investment on your part. We can't do the work. You're the one who has to do the work, and you can do it. I mean, getting there is the first step, and that's the biggest step, I think. And then you go from there.
I find it so interesting that things that both of you said about, you know, you want to be prepared for this, and what is portrayed in movies and TV is very off. And I think it was very interesting, Dr. Tilden, when you said that, what clinicians do is they prepare you and give you the tools so that you can make the right decision. And from my perspective, that's exactly what you want in a case like this, in a family law case where, it is going to be stressful. It is going to be a lot of things that you kind of have to parse through, and that you're going to have to work toward. Like, that's exactly what you want. Um, I see some comments in the chat, and I do want to invite everybody, if you have any thoughts, questions, concerns, whatever, feel free to throw them in the chat, and we'll ask our professionals here
Can I just add one
your
more
questions.
thing? I just wanted to add
Absolutely.
that a very common misconception is that therapy is for people with like severe mental illness, and not just like some anxiety or depression, things like that, or that it's a sign of weakness. There's still a stigma to a certain extent about going to see a therapist, and people think like, you're so weak, or that means you're crazy, or things like that. And it doesn't mean that. It's a sign of strength, actually.
Absolutely. Absolutely.
It really is.
Oh, go ahead. How can clients prepare themselves emotionally before entering mediation or court?
Before entering court, I would say, just to kind of try to be as grounded as possible. Um, do physical exercise, maybe meditate, or, do some mindfulness exercises so you're as calm and as peaceful as you can be, knowing and like mentally preparing for this is probably going to be unpleasant. It's going to be highly conflictual. But I have these things that I can do on the side to help me, like at the end of each, court session, or, at night, or, whatever you need to do to prepare yourself. Just really focusing on having as healthy of a life as you can outside of those situations, the actual court proceedings.
As far as legal strategy, it's always good to meet with your attorney prior to going into mediation. You need to be very well aware and informed of all your rights and possible outcomes, depending on the scenarios that are played out before you agree to anything. So the last thing I would want my client to go in on a mediation without a full discussion of what it is that they can or can't get out from a legal proceeding if it were to go to court, and what it is that they can or shouldn't negotiate in the mediation. Because the last thing you want is your clients to pay for a mediator, go into mediation, and sometimes mediation is not just one mediation session. It can be multiple. So they're going to end up investing a lot of money into this. And then they would come in or come out no longer in agreement because they realize that they agreed to something that they're no longer happy with, or that, goes against what they could have gotten in court. So the last thing you want is for someone to feel that way, but to be well informed is the way to go before you step into a mediation.
Yeah, I agree. And I also think a lot of people who go into these family law cases are very angry. And that, to learn some like anger management skills so that you don't, get upset and say something maybe you don't want to say, or that, looks poorly upon you. So, the adversarial nature of the custody battles, like that can just escalate. So you get poor emotional regulation, and then it goes back to what we were saying before in terms of like how to manage the emotional regulation, because it's a really unpleasant experience for pretty much everyone involved. And and it takes a lot. It can go on for a long time because these custody evaluations take a really long time. You have to say they have like a guardian ad litem appointed, and then they have to interview everyone, go to their schools, go to their homes, talk to both sides, any other collateral sources. So it's a time consuming process.
Mm-hmm. It's definitely a time consuming process, and it takes a lot of, I would say, emotional energy, mental energy, and obviously financial energy to go through the entirety of the process.
Yeah, and I think there's a big perception of threat on the person going through the process. Like, okay, this person's threatening my, relationship with my kids, or, threatening other parts of my life. So there's a heightened stress response, and that can make someone really defensive. And it also affects their emotional responses.
Right. And I cannot blame anyone for being on the defense in a divorce, whether it's the party that's filing for the divorce or the person that received the summons from divorce. Because at that point, there's essentially, I'm going to put in quotations, a threat of losing part of your money, part of assets, talking about debt. And then, of course, if there are children involved, losing time with your children, or losing the ability to make decisions on your kids. So it's a restructure of your entire life moving forward. So.
Yeah. And, more than 50% of parents involved in custody disputes have either anxiety or depression. It's a huge amount. And then also sometimes PTSD. So it affects an enormous amount of people.
Yeah, I was actually reading just earlier today about how people can go through litigation and experience PTSD from it. Um, but it totally makes sense. It's a high stress environment that has, impact on your life. So we do have a few questions in chat, so I'm going to post them up here. The first one, what are the first few steps you will advise a couple to take before starting the process of divorce? Thanks, Chica.
Well, you go ahead.
Okay. Thanks for the question, Chica. So when I have a client or a potential client call me and tell me that they want to file the divorce, the first thing I ask is this something that's already been discussed with the other party? Sometimes in certain situations, you cannot discuss it with the other party because there's domestic violence involved. There's some sort of threat or fear. So there is no discussion. But in the scenarios where you are able to discuss a divorce, I would definitely encourage that to happen. Because if there is anything that you can agree to before coming in and litigating, that'll save you a lot of headache, that'll save you a lot of money, it'll save you a lot of emotional energy and mental energy. And I have clients that will tell me, okay, great, I'm going to talk to my spouse. We're going to see what we can agree to. And sometimes they agree on one thing. Sometimes they agree on everything. But even if the one thing is relating to the children, that's still a win. Even if the one thing is who's going to move out of the house in order, to have some sort of equilibrium, some sort of peace, if they need to separate, that's a win. If the agreement is in relation to how they're going to divide something, like retirement accounts, that's still a win. And everything is everything else is up in the air and they need help from legal professionals to discuss, to negotiate, or to litigate, that's still a path to move forward.
Yeah, I would say, if they can even meet with a therapist like once or twice to just kind of iron some stuff out and maybe, try to make an agreement that we're going to make this as civil as possible because we don't want to hurt each other anymore. We don't want to hurt the kids. So that could be helpful. And just kind of realizing, accepting that, like, this is going to be a tough process. It's probably very likely it's not going to be pleasant the whole time. And kind of just, make yourself mentally prepared for what you're getting ready to go through.
Absolutely. Absolutely. So this is a two-part. It's a one part in the comment, but I have an additional question going along with that. Does the current mental state of a spouse warrant an ex parte order for temporary custody? And my question is, what is an ex parte order?
Right. So an ex parte basically means that you
Ex parte.
filed a motion, yeah, without the other side's knowledge. And it was granted because a court found that if they had been informed of this motion, then greater harm would have occurred. So there has to be a finding that the judge or the court should move forward without the other party having notice. If a court finds that this does not warrant, so what you're alleging does not warrant an ex parte order or an ex parte motion to be heard, they will tell you that they're going to have it continue to a different date, that you need to give notice to the other side, and the other side needs to appear at the court date in order for the court to hear their side of the story, essentially, before rendering a ruling. But okay, for temporary custody. So in Illinois, there is allocation of parenting time, and then there's allocation of decision making. So we use custody just in layman's terms because the legal jargon is just legal jargon. So for parenting time, it's who gets to have the kids, what days, what times. For decision making, who gets to make decisions for the big categories: medical, extracurricular, education, religion, daycare. In order for you to allege that the mental state warrants an ex parte custody order, you have to essentially prove endangerment to the children. And it can't just be a blanket statement. There needs to be evidence. There needs to be warranted facts for that, because it is such a huge allegation that you are making. Depending on what it is that you're asking for, which is either probably to suspend parenting time, terminate parenting time, because of the endangerment that's involved. So making just a vague statement usually is not good enough for you to have some sort of temporary custody on an ex parte basis. But if you have the evidence and the proof, then a court will likely enter that on a temporary basis until more evidence is provided to prove otherwise. But the safety of the children is always the number one concern of the courts.
Makes sense. One more. How do you counsel clients to separate the anger for the opposing party to facilitate a more productive process? Dr. Tilt?
I would say that a person is kind of, in order to separate the anger for their like ex-spouse, whatever, that they need to really like be centered, and think about like what's best for the children, whether it's like sitting down and making a list of all, the good things for the kids, or, you know, how you're going to keep grounded and how you're going to try to reduce your anger, and whether that be through therapy or, which I would suggest, or just, try to help yourself through like physical exercise and emotional regulation.
So just to add on to that, what I usually tell sorry, I think I'm lagging. What I usually tell my clients is, look at the other side the same way you'd look at a bank teller. Take the emotion all out, right? We are literally here at this point to do a business transaction, which is a separation of your assets. We're going to talk about division of your estate. If you have emotion involved, the process is going to take way longer. And then the remedies that you're expecting may not be reasonable because your emotion is getting in the way. So if you tell me that you hate your spouse and you wish whatever it is that you wish upon them, and you don't want them to get a cent from the estate, then it's my job as an attorney to tell you, well, I'm sorry you feel like that about, your spouse. I'm sorry you went through whatever it is that you went through, but legally, they're probably going to get X, Y, and Z, and you're going to get X, Y, and Z. So I need you to see that so you don't spend thousands of dollars on hearings and trials and then, proceed in that way.
Yeah, and I think going back to like the perception of threat, because they are so worried about what's going to be taken from them, that then they're very stressful, which is bad on your body because it releases cortisol, which is not good to have coursing through your body for a long term. And then that leads to like decreased frustration tolerance and poor decision making. Again, because they can be so emotional.
If both parties have agreed to get a divorce and they are civil about it, is it fair to make the children start therapy before the legal process?
My opinion is yes.
I would say yeah.
Therapy. This is me on my soapbox. Therapy is great. I was put in therapy at a very young age, and it's had a profoundly positive impact on my life. So to contribute to what Tracy and Mervat were saying, yes.
Yeah,
Yes.
like Mervat said, the primary goal is, from family law perspective, is to protect the kids. And also I would say, the same thing through like a mental health perspective. The best thing you can do for them is have some protective factors in place for them, and maybe try to help them understand what's going on, it's not their fault. To just kind of have someone other than their parents to go talk to and vent, cry, whatever. And it's a safe place where they can express all their emotions, and that will help in the end. That will help them.
In a domestic violence case regarding the distribution of assets, if no assets exist other than an active LLC, how can I get alimony?
So alimony in the state of Illinois is also known as spousal support or maintenance. In order for that to be calculated, a court needs to see what the income is of each party. So if you think that there is hidden income and it's going directly to an LLC and you have an attorney, I guess the job would be is to find out what income, if any, is being generated from this LLC, who it's being paid to, and how it's being used. If there's absolutely no way to trace that, then maybe the way to look, and you can talk to your attorney about that, is how is this person paying for their expenses on a month-to-month basis? What is it that is needed in order to pay for these monthly expenses? You can't go into court saying my monthly expenses are like $5,000 to $6,000 a month, and I magically pay them from a hidden asset. The money has to come from somewhere. The court can impute income on both parties or one party if there is a finding that there is mischaracterization or misrepresentation of the assets or misrepresentation of the income. So the court does have the discretion to assign, which is the imputation stage, of income if you think that there's a hidden income through an asset. I hope that's helpful, but I would definitely tell you to talk to an attorney about that because every single case is very different than the other.
Yeah, and just anecdotally, I have a friend who was going through a divorce. They didn't have kids, and they had a few assets, but the spouse was not producing documentation to the court and would only produce it when he was going to be held in contempt. So it just drug out the whole process. It took 5 years for them to get divorced, which it seems like a really long time if you don't have kids or just a few assets. But really, she didn't know what assets he had because he was hiding the information. So it can create a really long, drawn out process, which isn't good for anybody's mental health.
It's not.
How many sessions of therapy for myself and for the kids are minimum best practice during a contentious divorce? Or should I think of it as a weekly event?
Yes, I agree. You should think of it as a weekly event. To get the most out of therapy, you usually need to go on a consistent basis, not like once a month or something. Unless you're like stabilized and you've been going for a while and you just want to check in every once in a while. But for most people, you do go once a week. And you could do a couple sessions like you and with your children, and then I would suggest having the kids have their own session and then you having your own session independently.
Yeah, I mean, as we were talking about at the start of this, a divorce proceeding is a very stressful event for everybody involved. So it's uh, it's totally understandable that everyone would need uh, counseling both together and independently.
Mhm.
So this question is for Mervat. How do you handle situations where a client's emotional state is actively harming their legal position?
So I would say I have a direct conversation with every single one of my clients, and I like to be as forthcoming as I can with them. Um, you have to be real. If they are harming their own case, you need to let them know. You need to tell them to stop the alligator tears if you know that they're faking it. You need to tell them that they need, depending on what it is of the emotional state. If it's genuine, it's genuine. I'm okay with my clients being genuinely sad during a hearing. If they need to cry, that is completely okay. In the end, people are people and they are human. But if someone is throwing in theatrics, thinking that that is going to help their case, then you as an attorney need to stop it, right? Especially because it will harm their case, right? Judges are people and they're human as well. They're going to assess credibility. Is this person an exaggerator? Is this person a liar? Why is this person crying, for instance, because we're talking about who's going to be awarded spoons and forks that they got from IKEA versus them not crying when we're talking about, people, or I'm sorry, talking about parenting time for their children? Or is this person lashing out and calling the other person names and cursing them out? That shows a lack of respect. That shows disrespect, right? That shows the inability to co-parent. That shows the inability to be civil. Is this person not rational? You need to really have that talk with your client. I always tell my clients, look, mom or dad, I need you to be the best parent in the world right now. You are going to be dad of the month. You are going to be mom of the month. I need you to look and represent yourself in the best way possible, because we need the best outcome possible. But if you think that being irrational, being theatrical is going to get you the best outcome, it really isn't. It might lead to devastating results. It might lead you to being held in contempt of court, depending on what it is that you're doing, throwing out curse words, talking back to a judge, throwing hands. We don't want that. We don't want that at all. So it's really about being just very forthcoming with your client and the expectations. And I think every attorney has expectations that their client's going to be civil and very professional and sophisticated in a courtroom, and even with the other side, just so their credibility is assessed as the better credibility than the other person, just so that we have a better outcome. And of course, I would hope that that's also being demonstrated outside of a courtroom or an office.
Well, and I might add that, then if you're like so angry and and it's hurting your case, Another, sometimes with parents, I found in custody evaluations that there becomes like parental alienation and coercive parenting, and trying to manipulate your children, try to get them on like your side, and to say things that might not be true. Um, so there's a whole lot of negative things that come with that comes with this.
Well, yeah, and
Absolutely. I
to
mean,
add on, I'm sorry,
go ahead.
Aaron, I really think I'm lagging.
No
Okay,
worries.
just to
No
add
worries.
on,
Go ahead. You have much more to add than I do.
to, yeah, so just to add to Dr. Tilton, there are negative implications to this. So if you are so angry and you're coaching your children, it can be found that you are alienating them, and that can come through a 604 evaluation. And with alienation is detrimental outcomes like a turnover of the child completely to the other parent, or limiting parenting time or suspension of parenting time. There can be found to be endangerment to the kids depending on what it is that you're doing or saying to the children. Or are you a person who wants to paint the side paint the other side in such a bad light that everything that you're doing is a lie? Are you making allegations that the other parent is assaulting a child when none of that really happened and you know it? And you put the child through evaluations that they should have never, ever gone through. Again, as an attorney, that would be very concerning to me. It would be an issue of, does my client need their mental health evaluated at that point? Do I need to talk to my client about seeing a therapist? Because clearly there's something wrong if they're making up allegations, if they're lying about what's going on with their child, if they're willing to put their child through the ringer, knowing that none of that happened, then we definitely need to talk about evaluating mental health.
Yeah, and I mean, if they're trying to manipulate their children or making things up that their kids said, I mean, that shows that they have very poor judgment at that point in time. And so what's going to happen? Say they get the kids full time. I mean, are you going to continue to exhibit that poor judgment? Because you want to be making the best decisions you can for your children. And if you are like so angry you can't see straight, and your emotions are all dysregulated, then maybe ask yourself, well, how am I going to be able to parent well, even maybe after this is concluded? So to really meet with a professional and try to get a handle on your emotions.
Yeah. I mean, we've seen time and again that mental health has a huge impact on decision making. And in a situation like family law cases, that impact extends beyond just the courtroom. It extends to how you're relating to the people around you, to your children, to everything. And it's definitely one of those situations where I feel like it's easier to make bad decisions than it is to make good decisions, just because you're in this state of just constant stress and worry and anger a lot of times. Um, so, Dr. Tilden, I did want to ask you, this kind of leads into this question. How do you support clients who feel overwhelmed by the process or genuinely fear the outcome?
Well, I think, one of the places you can start with your client is to say, okay, let's go over the pros and cons of some of your behavior. Like where is it getting you? And just to offer your support and say, like, we're gonna work on, decreasing your anger, decreasing your making sure you have more emotional regulation. And, through cognitive behavioral therapy, which is what I practice mainly, you really focus on your thoughts and how your thoughts affect your behavior. And then, we try to provide you with these tools and insights that you can use to like have an intervention between the two, so that you're not making bad decisions that are then, it becomes circular. Like you make a bad decision. So maybe you do something impulsive, you do something coercive, and then it lengthens the process. And then you're going to be, upset for longer or more upset. So it's really detrimental to their mental health. and just give them support, and like it's a safe place. You can say anything you want about your spouse in here, and that's fine. Um, but we want to make it so when you're in court and interacting with your children, you're on good behavior, and it's a more positive experience for everybody.
Yeah, it's like there's an appropriate place for certain things, and
Exactly.
courtroom is not the appropriate place for a lot of it.
Yeah.
Yes.
Um, this one's for Mervat. What role does documentation of emotional or psychological concerns play in the family law cases?
So, first and foremost, if your mental health is not a concern in a case, then it's not going to come into play. If someone's mental health or state of mental health is an issue and it comes up as an issue, then it's definitely going to come into play when it comes to either a mental health evaluation. Are you competent to stand trial? Do you need a guardian ad litem? And I'm not even talking about the children, I'm talking about the other parent or the other party if there are no kids involved. You know, is there a physical evaluation that needs to happen? So there's something called in Illinois law rule 215A, okay? Or there's a B and a C and a D. Nonetheless, there's an evaluation for mental health. And that usually comes in when someone says this person is not mentally able and competent to make their own decisions. They literally cannot come in and tell you that they can pay their bills by themselves, that they can make logical and reasonable decisions when it comes to them, even financially. And if that is going to be an issue, then whoever is requesting this test has to be the one to file it, and most likely the person to pay for it. Okay. If it comes back and the person is not mentally able to make decisions, they're incompetent essentially, unable to make decisions on behalf of themselves, then it becomes an issue of whether or not a guardian ad litem needs to be appointed for that individual in order for the case to proceed. Okay. I've only seen this happen once. Because you have to go through an I would say a very detailed evaluation with a mental health professional who is licensed to do that type of evaluation. When it comes to children, there is something that is also the 215, and then there's a 604. So it's essentially the custody evaluation. I've seen in some cases, as a guardian ad litem myself, where we need the mental health evaluation of minor children because these children have mental health difficulties. You know, we need to see what resources, if any, is needed for the child. Is the mental health issues interfering in the way of having a relationship with one or both parents? Is this child self-harming? You know, there's a lot of issues that come at play if we're going to be doing a mental health evaluation for a child. For a 604 custody evaluation, and Dr. Tilton can talk a little bit more about this, but we're essentially assessing both parties and the children, seeing if there are any issues between the child and one or both parents, how the relationship is between the child and one or both parents, whether or not there are issues such as alienation, whether there are other mental health issues, what it is that's in the best interest of the child as far as decision making, like who should make the decision, should they be made solely by one parent or jointly by both. And then for parenting time, what the schedule looks like. But I'll have the doctor go ahead and explain that a little further.
Yeah, well, just to address what you were talking about in the beginning, is that I used to do competency evaluations, and they're very long and involved, and they're costly. So, if you're thinking someone's incompetent, then absolutely you should get one. But it does draw out the process somewhat, and that creates, more stress, more anxiety, more, irritability, depression, whatever is going on with you. And then in terms of like custody evaluations, again, they're very involved. They're very, very detailed. They're very long. So, I mean, it's worth it because you want to, have them be with the healthiest, best parent. So that, you're assuming that's going to be best for the kids then. So it is worthwhile if there's, a question about that. And just to, again, to see therapists while you're going through that too, because it can be very nerve wracking to people. Because again, they might lose their kid.
Mm-hmm.
So
And then
I have a follow-up. Oh, go ahead.
I'm sorry. I was going to say with a 604 evaluation, as an attorney, we always take a look at it and see, whether or not the evaluator took all the steps that are needed to come up with a recommendation. Do we need our own individual evaluator? And that's allowed under the statute. Do we think that our evaluator is going to come up with a completely different recommendation? And the beautiful thing about having your own individual evaluator, which you're allowed under 60410C, is if it comes back and it helps the 60410B, the court's evaluation, you don't have to present it because it's your own independent evaluator. Sure, you spent thousands of dollars only to get the same result, but I always tell clients, if you're going to go that route, you have to be 100% confident after we've talked about it that you're willing to take that risk, right? But if you know between yourself that everything was done right and we've gone through everything and we've talked about it, and even though you don't like the recommendations, just because you don't like it doesn't mean they're not right. So just because we talked about it and you think it's not right doesn't mean that you should go get your own independent evaluator. But if you think and you see and you and your attorney assess that there's something very wrong in the 60410B evaluation, then you always have a right to go seek your own. And these experts come into play and their evaluations weigh heavily in the outcome of any custody dispute. So it's very important to take it very seriously and to actually attend the appointments and, to maybe prepare for the appointments and make sure you give them the materials that they ask for and don't delay it. No game playing. You're paying thousands of dollars for this. So why would you do that? Some people do. I don't know. Why are you giving the evaluator a hard time? It really reflects then on, your personality, your character, your behavior. It's all going to go into the evaluation. You're not doing yourself any favors. So, just make sure that you take it seriously because it does play a huge role in your case.
Yeah, and that's something maybe you could answer, Mervat, is how much do you think the judges and the courts in general rely on the custody evaluation reports?
Yeah, if it's not challenged, then they rely heavily on it. They'll go through the recommendations and see what it is that the evaluator has stated needs to be done in order for the child to have the best outcome. Because again, the child or the children are the number one, I would say, number one thing in the eyes of the court. We need to make sure the children are safe. We need to make sure that the best interests of the children are at play. So if there comes back an evaluation, let's just say, and both parties say, sure, the evaluation came back, our clients agree to it, then the court is going to take that recommendation and probably roll with it. They're going to move forward with it. They're going to want to implement it. If it comes back and one party says, I'm contesting it, whether in part or in whole, then the court has to wait and see if this person is going to get their own independent evaluator. In the end, we have to see if there is a difference in the evaluation. If the court finds that, for instance, a 60410B evaluator was not credible, or they didn't do their job correctly, or they weren't precise and clear, whether the 60410C evaluator did a better job, what is the difference in documentation, in the interviews, in whoever they spoke to, what was the difference and why did their recommendations come out so differently? And the court would have to assess that. So, they do rely on it heavily, is the answer.
So we have another question from chat. Will an expert need to testify to explain a complex diagnosis like bipolar disorder or PTSD to the judge?
I've testified.
So you can try. Go ahead.
Oh, I said I've testified in court as an expert witness for things like that.
So I think the question is, do you actually need an expert? So you can always testify as to your own diagnosis, but again, you're not a doctor. So if you try to say that the doctor said, the professional said, that is hearsay. It will not come into court, period. You cannot be the one presenting documents and basically testifying to the documents because you're not the one who drafted them. They're not your documents. They're not your report. So if we're going to be strict about the rules, if the judge is strict about the rules, then you're going to have to get your doctor or a professional to come in and testify in order to get that evidence admitted into the court.
Makes sense. I did want to ask because we were talking earlier about competency and mental diagnosis and everything. But I've also because I've had friends, family, and a bunch of other people I know go through divorces. Um, and I've also run into the case where you see a divorce, but at least I have from the outside, and you can tell one party or both parties are interested in it more on the to cause harm to the other party. Like they're really just trying to make things as difficult as possible to the other party. Is there any sort of like relief or way to mitigate that both on an emotional sense in terms of with your therapist, but also with your attorney and in court?
Yeah, I mean, I think through therapy, something I would address, like from the get go, would be, let's take your spouse out of this. Just take him out of the room. This is about you at this point and what you're doing, like to harm your own case or, that prolongs mental health stress. What impact is this having on your life? Like, are your actions having on your life? Because that's what we want to really address. Is how can you make your life better through alleviating maybe some of that anger towards that person and your behaviors that are not helping yourself out.
So I like to bring this on, I guess a more human grounded, because there's only so much that you can say in legal jargon that'll help your client be calm or have the emotions come out, like in a way that is not destructive to their case, right? So I am always open to my clients talking to me if they need to vent, sure, but they know that I'm not going to give them any therapeutic advice at all. They can. Are there certain limitations to what words I can use, for instance? I don't know on the stream, but like if they, for instance, say my husband's an asshole, my wife's a bitch, my whatever, so they come in, they say all these things, they're angry. Sure, be angry. You can vent. Go find a friend to vent. That is okay. Go to a destruction room. I want you to just destroy everything in that room. You'll feel a lot better. Go hit the gym. Get yourself a hobby. Why do you always think about your ex? Let's move on. Let's not think about them in such a negative standpoint. They're a person that was in your life. You're moving on. You're going to go on to a better chapter without them. Just think of it like that. You need to take out your stress and your anger in a completely different way. We don't live in the medieval times. You can't go punishing someone because they hurt your feelings. You can't punish someone just because they don't want to be with you. You can't take money away from them because they don't want to stay married to you. Fortunately or unfortunately, people grow apart. And that's why we have divorce. And you just don't want to stay together, right? So it can be as simple as that, or it can be horrible, atrocious situations where you need to get out because of domestic violence, because of, emotional abuse, financial abuse, mental abuse, and you need to just get out. But we can't, unfortunately, through the law, quote unquote, punish someone. That relief is not there, right? Especially in Illinois, because it's a no-fault state. So any state that's a no-fault state, which I think the majority of states in the United States are, there is no punishment just because you want a divorce. So it's just looking for a healthy, avenue out to get that stress out. And therapy is number one, I think. But in addition to therapy, maybe, like I said, just do something that brings you some happiness.
Well, yeah, and one of the things also that I would focus on in therapy is what's the impact this is having on your children? Like, how is your behavior hurting them potentially? Like, are they having behavioral regressions? Are they like having nightmares? Say, like they're younger, maybe they start wetting the bed again, something like that. Um, you know, again, your priority should be the children's well-being, and so have to look at it from that aspect as well.
I think we have time for one more question from
Yeah.
chat. Oh, go ahead.
Sorry again for my lagging. Children do replicate the behaviors of their parents, and that should be noted as well. So, if the parents are constantly angry, fighting, as a guardian ad litem, I will tell you the children will see all of it, hear all of it, even if you think they aren't. They will report it. They will tell me as a guardian. Most of the children say that they don't like it when mom and dad are fighting. They don't like it when they hear them yelling at each other, that it brings them great sadness. Some kids blame themselves for it. So you have to really be cognizant of where you're having, these conversations, or, how you're acting or behaving in front of your children, because, believe me, they do see it, and they're going to start replicating that behavior.
Well, and to go back to the question, yes, there is patient client or therapist client confidentiality and privilege, and there are different types of subpoenas, and which Mavak could talk to more clearly than I can. But we don't. At first, we don't have to provide all the, depending on what kind of subpoena it is. We don't have to provide all the records. It's hard to break that therapist-patient confidentiality. So eventually, yes, we could be compelled to go and testify with, to our records. But it's not an easy thing to get. I mean, confidentiality.
No, it's not easy at all, actually. You definitely need to make sure you're cognizant of the HIPAA rights, and you need to go to court. If I'm the opposing side and I wanted medical documents, I need to file essentially a motion with the court asking permission, because you're asking something that is so private. You are literally asking to look at someone's medical records. And sometimes a court will narrowly draw what it is that you can and cannot have, and what you can and cannot see. So, whether the therapist will have to redact their files, whether they're only going to give you some things and not others, really comes down to what you're permitted to see based upon a court order, or what may be agreed to between both parties to release.
Well, and confidentiality is central to the good relationship between your therapist and yourself and the therapeutic alliance. So if people think, oh, anything I say in here could be discoverable, they might not be honest. They might not be invested in the process as much as they could be. So that's why we place such a high value on confidentiality.
Absolutely. Well, thank you both so much for joining us. Unfortunately, we're out of time. I'm sure I have a ton more questions, but I want to be respectful of your time and everybody else's. So thank you again so much for joining us. Thank you to our sponsors, Kiswani Law and LAMCO Wellness, and thanks to everybody else who's been so insightful and questioning in chat. See you.
Thank you.
Thank you.